Senator Booker.
Good afternoon, Mr. Blanche.
Good afternoon.
Our president has a very well-documented history of attempting to corruptly influence government officials to advance his own personal interest. He called the Republican Secretary of Georgia asking him to find enough votes to overturn the election. He withheld military aid to pressure Zelensky to investigate Joe Biden's son. For these things, he has been impeached. He's been criminally convicted in Georgia, indicted in Georgia, because he uses his power to unjustly influence people. When a president routinely pressures public officials for his own personal benefit, the Department of Justice has to remain independent. This brings me really to you, and I think what has you at the center of so much concern is that you seek to lead the Department of Justice after being the president's personal lawyer. The American people are really entitled to know whether your allegiance to the rule of law is your focus or your allegiance to one man who clearly has an insatiable appetite for revenge, self-enrichment, and the abuse of power. So I want to talk about your record. Under you, the department has prosecuted people that have caught folks on both sides of the political aisle by surprise. Jim Comey, Letitia James, my colleague Adam Schiff, Federal Reserve Governor Lisa Cook. This casts a shadow over your ideas, any ideas of independence. You directed the arrest of Mayor Ras Baraka of my city of Newark. You weren't at Delaney Hall on May 9th, 2025 when he was arrested, but yes or no, did you have a conversation with Special Agent in Charge Ricky Patel ordering him to arrest Mayor Baraka?
I had a conversation. I didn't order him to arrest. I authorized the arrest, which is my job.
So you were not there, and we have body camera footage of him then moving and saying, "We are arresting the mayor right now per," this is his quote, "the Deputy Attorney General of the United States." I want to put that into the record, your comments there. And the district court, assessing all of your conduct, admonished the Department of Justice. This is the quote of the judge, of the federal judge. "Your role is not to advance political agendas. Your allegiance is to the impartial application of the law and to uphold due process for all." But this is just one example cited by over 1,200 current and former Department of Justice officials appointed under presidents of both parties who warned that you should not be in this position because of your inability to be independent from your personal allegiance to Donald Trump over the rule of law. I met yesterday with Epstein survivors. Some of them are here in the room today. Congress, in a bipartisan fashion, passed the Epstein Files Transparency Act because the American people were demanding justice. Yet you failed to abide by that law and release the files by the deadline established by the law. And when the files were finally released, you failed to protect the survivors that law was intended to protect. Survivors' personal information, including names, phone numbers, home addresses, and images were released. Powerful people were redacted. Survivors were subjected to re-traumatization. More than 1,200 victims, yet only 2 people have ever been prosecuted, Jeffrey Epstein and Ghislaine Maxwell. Now, I was stunned earlier by your conversation with one of my colleagues that you wouldn't even commit to meeting with the survivors, but you did meet with Ghislaine Maxwell. Your claim that you can't meet with these victims because they're represented by counsel is utter nonsense. Counsel can be present or a client can waive their right to have counsel, but you're a lawyer. You know this. That was not truthful what you said to my colleague. You said that they should meet with the FBI. All of these women have reported their crimes decades ago, but yet you won't meet with them. What you will do is meet with Ghislaine Maxwell. Over a year ago, you sat with her, and you publicly said you were seeking the truth. So let's talk about what that 2-day meeting produced. Did your interview with Ms. Maxwell lead to a single additional person being charged, yes or no?
No.
Did it lead to a single new investigation, yes or no?
I can't talk about whether there's any investigation.
I'm not asking you about an ongoing or closed investigation. I'm just asking you
I
about
can't
this
answer your
unusual.
question, yes or no.
Did you or anyone else from the DOJ or associated with the president discuss a presidential pardon with Ghislaine Maxwell or her attorneys?
No.
Did you discuss clemency, yes or no?
No.
Did you discuss
She was convicted. What do you mean, Clemens?
Did you discuss her transfer to another institution, yes or no?
No.
Well, just 1 week after your meeting, Ms. Maxwell was transferred from a low-security federal institution to a minimum security prison camp. Were you involved with that transfer?
When, as I've talked about before, in the time leading up to me going down to meet with her, we learned that she was receiving threats. It turned out.
I'm going to interrupt you for a matter of time because.
Okay, well, it's not a question I can answer apparently in the time you're giving me.
I'm going to tell you this because I deal with issues of criminal justice. When people are under threats in a Bureau of Prison facility, they're put into solitary confinement or protective. They're not moved to a camp.
That's not always true.
It is.
You're
Well,
just
what
wrong.
what is true is someone that is accused of child sex trafficking under the Bureau of Prison's own policies is not put in a facility like this that seems clearly like a reward. The Department of Justice is also responsible that powerful corporations play by the same rules. Let's take a proposed merger between Paramount, Warner Brothers, and Discovery. This is no ordinary transaction. It was a proposed $111 billion merger involving two of the last remaining legacy Hollywood studios. As Deputy Attorney General and later Acting Attorney General, you exercised oversight of the Antitrust Division. You approved the decision to close the department's investigation into that merger, yes or no?
I was part of the decision. I
Yes,
don't know
you were
whether-
involved in that.
You
That
don't
is a
even
yes.
let me answer, man.
Did
That's
the
incredible.
career attorneys
The
who
answer to-
investigated that deal recommend closing that investigation?
I didn't have a conversation with the career, but as I was saying,
I didn't
earlier,
ask you
I
that.
was-
I asked you, did the career attorneys who investigated the deal recommend closing the
I
investigation?
have no idea what they
You were in charge of that department, yet you have no idea. Well,
I
this
didn't
is,
say I had no idea. I had no idea about the question you asked about what the career attorney's view was.
you do not know what the career attorney's view was.
I'm not sure what the view was with respect to closing it or not closing it.
Let me tell you why ethics laws that bind you about the appearance of impropriety are so damning in this case. On the same day that Paramount shareholders voted to approve the merger, David Ellison, the head of the acquiring company, hosted a dinner that you attended honoring the President of the United States. While you were at that dinner, the DOJ was still investigating a merger. Did you speak with Mr. Ellison on that evening?
No.
Did you discuss with anyone involved in that organization that evening the department's ongoing investigations?
No.
Well, 6 weeks later, after that dinner, that investigation was closed that you're stating you have no idea if the attorneys in charge even finished their investigation.
That's not what I said.
What did you say?
You asked me a question about whether the attorneys recommended that the investigation be closed, and I said I wasn't sure. That's different than what you just threw back at me.
Do you believe that that creates an appearance of impropriety that you were at a dinner?
No.
Okay. The Justice Department ethics rules are very clear about avoiding the appearance of impropriety. In a case like this, I don't think that's appearance of impropriety. I think that's improper. That the connected and the powerful are getting a chance to rub shoulders. It would seem appropriate that you avoid those kind of appearances and dinners like that.
Every appearance or dinner or speech that I give are cleared by ethics officials.
So your attendance at that dinner was cleared by ethics officials?
Everything that I do.
I didn't ask you everything you do. Was your appearance at that dinner
You
cleared?
can ask the questions, but you cannot control my answers. I'm under oath, and I can answer the questions. I choose to answer them.
Were you
so what I will
approved
tell
to
you
approve?
is when I do
Yes
things
or no?
outside, when I
Were
do
you
things,
approved
when
by
I do
ethics
things
to-
outside of the department, whether it's a speech, whether it's a dinner, whether it's an event, they are approved by ethics officials.
You did not answer whether that attendance was approved.
Every time I go out, it's approved. Yes.
You know, Lincoln, it was said about him that if you want to see the true character of a man, don't view him in adversity, give him power. I believe you've had a lot of power. And so we don't have to speculate about what has been revealed with your time in that office. We don't need to worry about what kind of attorney general. You've already had that power. This isn't a job interview like usually. You've sat before this committee before. You've made promises time and time again before. You got the job, actually, to be the number 2 and the acting director. So this isn't a confirmation hearing. This is more of a performance review. And clearly, when it comes to the treatment of Epstein victims, when it comes to politically motivated prosecutions, when it comes from avoiding appearance of impropriety with corporations, you failed. You're asking this body for a promotion. And you've spent today making a lot of promises to follow the law, promises to be independent, promises to serve the American people and not the president. But we don't need your promises. We have your record. We have watched you exercise one of the greatest powers entrusted to any public servant. And what have you shown us? 1,200 victims waiting for justice. What have you shown us? There's 2 prosecutions. While the people involved, the victims, are waiting for action, one of the people prosecuted gets the most cushy arrangement possible after you visit with her. Again and again, you seem to be favoring the interest of a president and the powerful. You've chosen Trump over truth. You've chosen corporations over the Constitution. And you failed to meet the test. I'll say this in closing. This is why your nomination should fail. The Attorney General's client is not the president. It's the American people. You've been protecting one man for most of your career, for years and years and years. He has demonstrated himself to put undue pressure. This is why he was impeached. This is why he was criminally indicted. If your record and your testimony today should show us anything, it should show you, in my opinion, that you should not be confirmed to this job.
Senator Whitehouse.
Morning, Mr. Blanche.
Good morning.
Why won't you tell us what became of the $50,000 in confidential money that the FBI reported that it gave to Tom Homan?
I'm not aware of what you're speaking about. To the extent that there have been public reporting about an investigation, I know nothing about it.
Well, the public reporting is that the FBI reported giving $50,000 in the nature of a bribe to Tom Homan, and there's been no report of what became of that $50,000. Will you answer that question? Not now, but will you answer that question? Because we've been asking for a long time now. Your department certainly knows what's happening.
I'm not aware that that's true.
Well, take a look at it, and it's publicly reported, and the FBI reported it, and you should answer the question. That's not the only one. Here's a list of unanswered questions that I have just asked. I don't know how it is that the chairman thinks that you've cooperated with the committee or that you've been transparent with the committee. That is not my experience. You said earlier that you welcome our questions. Great. Answer our questions. That's the real point. Where we've failed to get answers to our oversight questions, we've actually had to revert to the Freedom of Information Act, the general law of government transparency, to try to get answers from the Department of Justice. Here's how we did. Not well. We have this stack of questions that you haven't answered in the nature of oversight. We have this stack of FOIA requests that you haven't answered. And I think it's important for us to believe that you actually take seriously your constitutional oversight responsibilities in order to confirm you, that you actually take seriously your obligations to this committee, irrespective of party, majority or minority, in order to confirm you. So I will ask before we get to a vote on this that you take a look at these and get us answers. Where we have had answers, Mr. Blanche, they have not been informative. They have been blow-offs. So let's move on to Trump versus IRS. Our research indicates that senior DOJ officials have never in the history of the department before faced a judicial inquiry into a fraud on the court participated in by the Department of Justice. That was the inquiry opened in Florida. The question about fraud on the court committed by the Department of Justice remains open in the judge's decision. Here's what she did find. She found that the Department of Justice colluded with the Trump plaintiffs, that the Department of Justice violated DOJ policies in that collusion, that department attorneys were derelict in their responsibilities as DOJ attorneys, that the department failed to zealously advocate on behalf of the United States of America, its true client. And as I said, the fraud on the court question remains open, an unprecedented allegation about the department. As a result of that, the order was transmitted to the New York State Bar for potential disciplinary proceedings. I would like to ask, in addition, since this is new news, the decision was, 2 days ago? I would like to ask that you say to us that you will be willing to provide all of the documents and communications between the Department of Justice and the Trump plaintiffs in that matter.
I'm not aware of any communications. I didn't have any. So if you put a request in, we'll look at it. I mean, obviously that's active, continued litigation in the Southern District of Florida. So it depends on.
Explain how it is active, continued litigation in the District of Florida.
Well, there's been several indications that the parties I never entered notice of appearance, but that the parties intend to appeal the judge's Monday 56-page decision.
Well, it'll be interesting. Do you intend to appeal the Department of Justice?
We weren't really even part of that decision. So to the extent there's something that we can appeal, I very vigorously will encourage the department to do so.
Well, here's the tell. In that case, the Department of Justice filed no answer, filed no agreement with respect to the extension of time, filed no response to the case or controversy amici, filed nothing related to the withdrawal of the complaint, filed no settlement, and filed no response to the fraud on the court inquiry. To me, as a one-time litigator, that looks like really weird behavior. And when for the first time in history there's an inquiry into fraud upon the court committed by the Department of Justice, the silence from the department in response to that is deafening, Mr. Blanche, deafening. And it strikes me that the stratagem here was to file no pleadings, to try to keep the department out of the authority of the court, when what the department knew to be a collusive and false enterprise was blown up in that court. Now, it didn't work because the court found collusion, and it takes two to collude. And they also went on and made the other adverse findings about the department's conduct. And the problem here, Mr. Blanche, is that it's not just that one occasion. Between judges appointed by every president harshly criticizing the department's work in your tenure, grand juries rejecting indictments, judicial findings of outright misconduct, capable lawyers fleeing the stinking ship, this seems to be the most troubled Department of Justice in history. Here are some of the misconduct findings against your U.S. attorneys. And if I haven't put it up yet, here's a word cloud of the commentary by federal judges about the conduct of your DOJ. These are red flag words that when I was a U.S. attorney would have provoked, at minimum, an internal conversation about what the hell went wrong, and very likely a conversation with OPR and maybe OPR pursuit. Words like pretext mean a lot coming from a judge about a government argument, usually enjoying the presumption of regularity. We need answers. I need you to be able to tell me that this kind of misconduct is going to stop if you're confirmed as Attorney General. Can you say that?
The Department of Justice works hard. The prosecutors work hard every day, and I appreciate the hand-picked words that you have behind you right now, but that's not reflective of the 100,000 indictments and informations that have been filed to do the work that I talked about earlier today. And so while cherry picking a few isolated words from district court or magistrate judges in certain districts is something that you're entitled to do, it's absolutely false to suggest that this Department of Justice is not executing as we should and doing the right thing every single day.
I will tell you that you are wrong, that in the history of the department, this kind of criticism by federal judges is unprecedented, and it comes from judges of every different political persuasion. Let me ask about the FBI. How long do you intend to put up with that Kash Patel character? Are you good with his airplane jaunts? Are you confident he's not drinking on the job? Are you sure none of his travel is a pretext for vacation activities like snorkeling, Olympics, and visiting girlfriends? Are you sure he knows what he's doing? Do you vouch for him? Are you willing to look at whether he lied to this committee?
That's an extraordinarily obnoxious question, Senator, and I have full faith in Director Patel and the work that he's doing every day.
Great, you get to own that. One last thing, if I may. You have refused to exclude January 6 rioters from your anti-weaponization fund. You have refused to put in writing that the slush fund is dead. Indeed, you signaled to allies that payouts are still on track. You have vacated seditious conspiracy convictions against members of the Proud Boys and Oath Keepers. You hired January 6 rider Jared Wise, who had urged the mob to kill police officers. You scrubbed press releases about January 6 prosecutions and called the releases partisan propaganda. You denied that Trump encouraged any violence on January 6. You've cleaned house of every attorney who worked on a case related to Trump, and you've bragged that bringing justice for violent rioters meant that every one of them was either pardoned or had their sentence commuted. I hope that our colleagues who are concerned about what happened on January 6th take that into account. Thank you.
Would you like to respond?
I would. Almost everything the senator just said, and he's protected, he's allowed to lie, but almost everything he just said was absolutely false, okay? Starting with the fact that I have never said that any sort of violence against law enforcement is appropriate. I have never said that publicly. I have never said that in a speech, and I certainly do not believe it. I did not hire the person referenced, and that is, again, something that just happens not to be true. When I talk about what happened with the convicted January 6 defendants, I talk about what President Trump did. He has the absolute right to pardon anybody for any reason he sees fit, and every one of them got pardoned or commuted. I am not celebrating that. It is a fact. And the fact that my department had to take action in response to those pardons by dismissing some cases is exactly what I have to do under the law, and it's what I did. So that the narrative that the senator just suggested and put on me as something I believe is absolutely not true.
Since he accused me of lying personally, Mr. Chairman, let me ask that I put this series of concerns into a question for the record, and that you, under oath, one by one, tell me where there's a lie.
I'm happy to do that.
We'll get that to you.
I'm happy to do that. Absolutely.
Thank you very much, Mr. Chairman. Mr. Blanch, thank you for coming by my office yesterday. I think we both knew going into that meeting that we had strongly held political beliefs on both sides of the table, and yet we had, I think, a respectful exchange, and I thank you for coming by.
Thank you.
I'm glad you brought your staffers with you. My staff was there as well. If there was any misunderstanding, my representation of your remarks, you'll have a chance to correct the record in a few moments. But I'll do my best to stick by what I said, and my staff has backed me up. And in my memory of it, yours may be different. But thank you for meeting with me yesterday. I want to acknowledge the obvious empty seat at the dais here, which the chairman, next to the chairman. The committee is mourning the loss of our friend and colleague, Senator Lindsey Graham, former chairman and ranking member of this committee. I served on the committee with Senator Graham since he joined the Senate in 2003. I'm going to cherish my memories of both our fierce partisan battles and our landmark bipartisan agreements. He was a trusted friend. My friends and family back home can't believe it when I say these things. You mean that Lindsey Graham? Yes, I do. He was a good person, a valuable part of the Senate family, and an extremely valuable part of this committee. I'm glad that we're honoring him with this memorial today. Let me say at the outset that the chairman spent several minutes talking about Jack Smith. I want to make one thing clear about Jack Smith, who was a special counsel. Months ago, perhaps 6 months ago, maybe longer, he volunteered to appear before this committee under oath and testify about what he did as special counsel and to answer the questions of the committee. For reasons I cannot explain, the Republican majority does not want to bring Jack Smith before this committee and have him testify under oath. They continue on a regular basis to take exception to things that he said or did or allegedly did, but will not bring him before this committee. I don't get it. If they have something they want to raise with Jack Smith, that place is where he should be sitting under oath and answering the questions, and he's volunteered to do it, but they turned him down. Mr. Chairman, we are here today with the awesome responsibility of choosing the next Attorney General of the United States of America. We're here because there's a vacancy in the office. The President decided to fire the predecessor of Mr. Blanche after just 14 months on the job, after courts and grand juries blocked her from prosecuting the President's political opponents. Seemingly, President Trump believes you, Mr. Blanche, will be more successful. When you were first nominated to be Deputy Attorney General, Democrats raised concerns about the President's personal attorney serving as the top attorney in the Justice Department. The Attorney General is the chief law enforcement officer of the United States of America. Since you were confirmed, the Department of Justice has literally violated dozens of court orders to advance the President's agenda. Last year, you declared that the Justice Department was, quote, at war with the federal judiciary. I brought that up to you yesterday. I believe all of us, both sides of the table, need to be more careful with our rhetoric when it comes to the judiciary. Yesterday, we had the testimony of Justices Kagan and Barrett, and they talked about the impact on them personally and on their families with the threats that have been increasing against them physically. Most of us on this side of the table know what they're talking about. We have a similar experience. But it is a responsibility of all of us, Democrats and Republicans, liberals and conservatives, in or out of the government, to be careful with what we say about the judiciary. They are doing their job. We should never, ever countenance violence against anyone on either side. One of your first official actions as acting Attorney General, Mr. Blanche, was to establish the $2 billion weaponization or slush fund to benefit January 6 cop beaters while immunizing President Trump from IRS liability. You defended the slush fund by claiming, quote, people hurt police, get money, who hurt police get money all the time, end quote. Despite resounding bipartisan criticism and admitting that it was a mistake, you've refused to rescind the order creating this fund. That order can still be found on the Department of Justice's website today. We talked about this yesterday in my office. I didn't quite understand your explanation. I'll give you a chance, of course, to explain it. But you said it was up to Congress to codify the elimination of this fund. This was a creation of the executive branch. It was not a creation of Congress. So I hope you'll clarify that statement. Earlier this week, a federal judge characterized your explanation of the settlement that led to this fund, quote, at best misleading and at worst disingenuous. You told me yesterday that the opinion was, quote, a hit piece on you, another troubling attack on a judge for doing her job. Then there's the cover-up of the Epstein files, which former Attorney General Bondi herself said you were, quote, in charge of. Under your leadership, more than 1,000 FBI personnel were pulled off of other priorities and directed to flag Epstein records for any mentions of President Trump. When scrutiny of the cover-up intensified, you participated in meetings in the White House Situation Room to strategize about how to protect President Trump, not Epstein survivors, the president. When Congress forced the administration to release the files, hundreds of survivors' personal information was unredacted, victimizing them again. Meanwhile, the names of powerful Epstein allies remain protected in clear violation of the Epstein Files Transparency Act. Your explanation, quote, "It isn't a crime to party with Mr. Epstein." Mr. Blanche, these survivors deserve much better. I want to recognize many of them who are in the audience today. I thank them for their courage in speaking out. Tomorrow we will hear one of them during our outside witness panel. I'd like to enter into the record 6 letters from Epstein survivors in opposition to the Blanche nomination.
Without objection, so ordered.
I'm asking you, Mr. Blanche, today, before you leave this room, to agree to meet with these Epstein survivors personally and to bring with you professionals from the Department of Justice to hear them out. They have the courage to tell their story, and they should at least hear from their government that they take it seriously. After your interview with convicted sex trafficker Ghislaine Maxwell, an attempt, I believe, to exonerate President Trump, Ms. Maxwell was transferred to a minimum security camp. That is unheard of for offenders like her. You said it was for her own personal safety. I hope you'll explain that today. You told me yesterday you want to be Attorney General because you love the Department of Justice and you love prosecutors. But you have removed from the department some of the most effective prosecutors that have ever served our government. Done that for personal reasons, purging career law enforcement officials who won't prioritize President Trump's interests over their oath to the Constitution. You fired the career pardon attorney because she wouldn't sign off on restoring gun rights to a convicted domestic abuser, Mel Gibson, personal friend of President Trump. You fired career immigration litigator Erez Reuni for refusing to follow unethical orders from your former law partner, Emil Bove, and other senior DOJ officials to lie to a federal court. You bragged about firing career law enforcement professionals simply because they were assigned to investigate the president's criminal misconduct, including FBI agents who specialized in investigating threats from foreign adversaries like Iran. More than 1,200 former career DOJ employees who worked for both Republican and Democratic administrations sent this committee a letter opposing your nomination because you have purged DOJ of thousands of experienced law enforcement officials, putting our nation's security at risk. I would like to enter this letter into the record with unanimous consent.
Without objection, so ordered.
You testified under oath last year that as Deputy Attorney General, you would consult with career ethics officials to avoid conflicts of interest, a significant concern since you received nearly $10 million as a president's personal attorney. But you've gutted the DOJ offices that handle ethics and professional responsibility. After the department's top career ethics lawyer advised you to recuse yourself from any matters relating to Trump in his personal capacity, that lawyer was fired. Every smarmy, suspect deal in this administration has cryptocurrency behind the curtain. And again, it has happened when it comes to the billion-dollar windfall that went to the president in his first year in office. Shortly after you were confirmed as Deputy Attorney General, you issued an order dismantling DOJ's crypto enforcement team and shutting down ongoing criminal investigations of the crypto industry. At the time, you owned at least $159,000 worth of crypto-related assets. While you eventually divested, those assets didn't go far. You simply transferred them to your children and grandchild. With the crypto enforcement unit out of the way, President Trump brought in $1.4 billion from his family's cryptocurrency business in 2025 alone. Take one example of the dealing in the administration. In April 2024, the founder of the crypto company Binance was sentenced to prison and ordered to pay $50 million fine for a money laundering scheme. $50 million fine. He then brokered a deal to channel $2 billion into the Trump family's crypto business, World Liberty Finance, after which President Trump pardoned him. Binance accounts have funneled about $1.7 billion to Iranian entities linked to terrorism. The president's World Liberty Financial continues to partner with Binance, even with these facts that I've spelled out in this statement. You recently claimed, quote, Mr. Blanche, that there's a ton of evidence that the 2020 election was rigged. You should see what happens in this committee room when judicial nominees of this administration appear before this committee, raise their hands, take the oath, and then field the questions asked by members of the committee. You'll see some of the people who are even judges today at state level and have distinguished careers in law start to avert their eyes, squirm, and then give a script which doesn't acknowledge the obvious. Donald Trump lost the 2020 election by 7 million popular votes. 7 million votes popular vote, and he lost by that number. That's a fact. Any eighth grader in America knows it and can repeat it for you. And yet when it comes down to asking Trump judicial nominees who won the 2020 election, you ought to see him squirm. What's the reason? The president's big lie. He believes in his heart of hearts that he somehow won that election, though he can't produce any evidence of that fact. Well, we'll give you your chance. I hope that you'll produce the evidence to show one way or the other that the big lie is the truth or not the truth. Your first indictment of former FBI Director Comey failed in a case brought by an unqualified and unlawfully appointed U.S. Attorney, Lindsay Halligan. So now Mr. Comey is being prosecuted for taking pictures of seashells. This prosecution, personally ordered by the president, who despises Mr. Comey for overseeing the investigation of Russian interference in the 2016 election. You have also baselessly indicted the Southern Poverty Law Center, a civil rights organization that has worked tirelessly to expose violent extremists like the Proud Boys and Oath Keepers, a group which we in the Senate know well for their January 6th escapade, the same people you gave a clean slate for their role in attacking this Capitol. A federal judge recently singled out your, quote, remarkable statements targeting Kilmar Abrego Garcia as evidence that his criminal prosecution was, quote, marked by a retaliatory taint for successfully fighting his deportation. And despite my repeated request, you've yet to produce the DOJ memorandum concluding that it was legally permissible for the President of the United States to accept a gift of a luxury airliner from the royal family of Qatar, despite constitutional and statutory foreign gift prohibitions. Earlier this month, that jet was launched as Air Force One, despite credible reports of security vulnerability. Last weekend, the Department of Justice responded not by addressing these concerns, but by sending federal agents with subpoenas to the homes of the reporters who exposed these lapses. In less than 18 months at the Department of Justice, you have shown you're still President Trump's personal attorney. Your tenure can be summed up in the 4 words you said, quote, I love you, sir, to President Trump. This was your response when you were asked what you would say to him. This nation deserves an attorney general who loves the Constitution more than any single president, an attorney general focused on keeping America safe and combating corruption, not satisfying the president's personal grievances or channeling crypto cash to the administration's MAGA faithful. Mr. President, Mr. Chairman, I yield.
Senator Schiff.
Thank you, Mr. Chairman. Mr. Blanche, you represented the president in at least three criminal cases, the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving the president, having been his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior
Yes.
representation of the president?
Yes.
So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself.
I'm recused, correct. Well, by the way, the
So-
cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to CPAC a couple months ago, the other things that are happening, there is not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
No, there is. I wasn't involved. That
So
would be a
at
conflict.
CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
I'm making, there's a statement I gave
you
at
were
CPAC.
bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting attorney general. So yes, my department moved to dismiss. I was not
So
involved.
you didn't recuse yourself from that matter. You were
No,
willing.
there's no reason to, from the Proud Boys matter?
Yes,
I mean,
it was.
lawyer, you know the rules. There are rules that say when I
yes,
have to
there
be
are
recused,
rules,
and that's not one of them.
and there are rules. And when you're told to recuse yourself from investigations
I
that
always
you
do.
handle for the president, you're supposed to recuse yourself.
No, when I
so
represented
you have
the president.
you have also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No.
has said
The
it cannot be
department's
released.
position under you, Mr. Blanche, the department's position under you, Mr. Blanche, was do not release the report.
So that position.
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
What you're saying happens to not be true. I did not do that. What you're talking about happened before I
you-
became the
you
Deputy
support the
Attorney General.
release of Volume
No,
2?
I don't, but I'm recused and it had nothing to do with that case. Like, you can't accuse me of violating my ethical rules and then lie about what I did.
So you had nothing to do with the decision to prohibit the release of the report. You had nothing to do with the department's
wasn't in court.
position.
I
No, I'm
wasn't
not
the
asking whether
deputy-
you were in court.
was-
I'm asking you whether anyone sought your opinion or used your guidance in refusing to release Volume 2.
When
Are you
that
saying you had nothing to
litigation,
do with
when
that
that
decision?
litigation was ongoing, I was a private citizen, still representing the President of the United States. It was before March. Since March, to the extent there's been anything in front of that judge,
Mr.
I
Blanche,
haven't been part of
I
it.
asked you in your last confirmation hearing whether you would release the report, and your answer was no. Your answer was not, I will recuse myself. Your answer was no, I will not release the report. That was your testimony last before this committee. You subsequently were advised by ethics lawyers not to be involved in these matters, but it appears you were involved in these matters. Let me ask you about another matter.
I
You were-
wasn't involved. You can't say it appears I was involved when I said I wasn't.
Let me ask you about another one you have your name on.
Geez, the truth has to matter at some
yeah,
point.
it does matter. We just don't hear much of it from you. But let me ask you about another matter you have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So
Yes.
you put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. It not having to do with
Well,
for tax
I'm happy to
purposes.
read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
The
Mr.
participant
Blanche,
there was not the president. It was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement, so any
So he
taxes,
hasn't filed taxes yet for money he made last year, right? So
yes.
no.
So if he
So no protection.
if he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this agreement you signed.
There's no evidence taxpayers were defrauded, and he
But
is not protected.
there's
He
evidence
is
in
not
this
protected.
agreement that
He's not
you've
protected.
absolved him of any liability over.
No, I just said he's not absolved. So the question
So this
was,
agreement doesn't apply to a tax return filed last year
To
or
tax
filed this
returns-
year.
to tax returns filed after the date of the agreement? No,
No,
it does not
before the
apply.
agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not
Yes,
after.
okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability, even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language?
You
by
have
the
to
way?
use the facts, though,
Did
that
you-
he hasn't
did
filed
you-
taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did you write this language?
No.
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is.
Was it one of the president's lawyers or was it someone from the Justice Department or IRS?
This document would have been
Yes.
somebody within the Department of Justice.
Well, you have no idea who that is.
I don't know the name of the person that typed it up.
And did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
I'm not a judge. I don't reject
But
things.
you
I mean,
signed an
there was-
agreement
there
for
was-
the
there was
U.S.
discussion around the
You signed an
litigation.
agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did. That's not what I said. I didn't
Well-
say that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund and this immunity?
There was a lot of discussion internally.
But you made the
about
decision.
case. What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision instead to sign this slush fund agreement.
We made the
with
decision
president.
to settle the case, correct?
Yeah. And in doing that, you basically decided that you were going to be the lawyer for the president and the lawyer for the IRS and the Justice Department. As the court found in this
No.
case, there was no adversarial relationship.
Yes,
the
there
court
was.
found it was a sham. It was a collusive relationship. And what I don't understand, Todd Blanche, what happened to the Todd Blanche who was a prosecutor in the Southern District of New York? What happened to the prosecutor people had respect for? What happened to the prosecutor who once respected the rule of law? What happened to the prosecutor who said that there wouldn't be a whiff of political partisanship and then prosecutes the president's enemies over Seychelles cases, over making a video stating the plain law and Constitution? What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot
never said
imagine
that.
the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche? I'll tell you this. I think Robert Caro had it right when he said that power doesn't corrupt as much as it reveals. I suspect it has just revealed who you are. And who you are is someone willing to sacrifice everything you once believed in for that title for that position of Attorney General. And it is a sad story that we have seen from Trump appointee after appointee after appointee. We have seen people compromise themselves little by little and then a lot by a lot until they're sitting before this committee and trying to justify the unjustifiable. I yield back.
Okay.
May I just briefly respond, Chairman?
Yes, you may.
Very briefly. So you asked me what happened to Todd Blanche. I am still here. I am the same exact person I was when I was a federal prosecutor in the SDNY, which is do the right thing and do everything you can to keep communities safe. So when I was a line prosecutor, when I was a supervisor, when I was the head of a division, my motivation and my goal was the same thing with the people who worked with me and worked for me, which is do the right thing, enforce the laws, and put bad guys in jail. And so you spend time talking about, I did not interrupt you. I did not interrupt you. A little courtesy would be appropriate. So when you ask me what has changed, okay, and you talk about a single document that I signed, okay, and somebody had to sign that document when the president sued, okay, so I tried to do the right thing. What I do every single day, and what the prosecutors in this country do every single day, and the nearly 100,000 indictments and informations that have been filed since January 20th, is exactly what everybody in this building should want the Department of Justice to do, which is to make our communities safer, enforce the laws, both civilly and criminally, and always do the right thing with integrity, which is exactly what I'm doing. So I am the same Todd Blanche I was when I was a federal prosecutor in the SDNY.
With me that it should not be the policy of the United States to do it.
But in your question, you're suggesting there is such a policy. I'm telling you there is no such policy.
Well, if there is no such policy, then I presume you would investigate it.
When I see the lawsuit, I'm just not familiar with it. We will, of course, do what's appropriate.
Well, you'd agree with me that it would be wrong.
That it would be wrong, meaning it would be wrong to send somebody home to be tortured. Yes.
Let me ask you about allegations in connection with David Gentile. I think we talked about these allegations when you visited me. Thank you for coming to my office. In May of 2025, David Gentile was sentenced to 7 years in prison for his role in an almost $1.8 billion Ponzi-like scheme that defrauded over 10,000 investors, many of them middle-class retirees, of their hard-earned savings, and he was imprisoned. He boasted to fellow inmates and others that he was going to be released because he paid $2.5 million for clemency. Evidence collected by the Eastern District of New York supported those allegations and reportedly also included statements by Father Frank Mann that he spoke to the president about David Gentile. The Eastern District of New York was investigating these allegations and reportedly received a call from one of your top deputies instructing them about the concerns of the Department of Justice. The investigation was stopped by the Eastern District of New York. I wrote to you on June 23rd and United States Attorney Joseph Nacella about these allegations, that an investigation into this impropriety was shut down at the request of your office. Did you have any involvement or knowledge about the commutation of Mr. Gentile's sentence?
President Trump, as I've said a couple times today, has full authority to pardon or commute anybody convicted of federal crime.
That's not my question.
So I'm answering your question, Senator.
Did you
I'm answering your question. What my communications with President Trump, I will not talk about. He does not, nor should he. He has no obligation to discuss pardon or commutation decisions with me, and he has not. As far as what you just suggested about an investigation, I believe you're referring to a news article that was the result of apparent leaks, and I would caution that there's falsehoods in those news articles.
I'm asking you whether you had any involvement in commuting that sentence or in stopping the investigation into the allegations of impropriety, possibly payment to Father Frank Mann.
And I answered the first question, but when you say stopping an investigation, there's an assumption built into your question that I will not concede. We will not talk about whether investigations exist or don't exist, and certainly some leak about something that we supposedly did doesn't warrant an answer either.
There was an investigation, correct?
That's my whole point in saying is that there's an assumption baked into your question that I don't think is true, meaning that we cannot comment on even the existence of investigations
You
like that.
commented this morning to Republican colleagues about several investigations.
No, I haven't.
Well, you commented in response to the chairman about the FISA investigation,
About the what? Excuse me?
the investigation that he asked you about.
So, Senator, my point is that you're asking me questions about a news article, the source of which was apparently leaks. It would be inappropriate for me as the acting attorney general to comment on such leaks or news articles that you're referencing. But
I accept that you're not going to answer my question, but I think there is a need for the Inspector General to look into the investigation that was apparently, according to these articles and other information, stopped as a result of your intervention. Let me move on. In 2017, more than 10,000 9/11 victims filed suit against the Kingdom of Saudi Arabia. That lawsuit is heading to trial. Information was promised by President Trump in September of 2019. That information has not been provided. Will you commit to meet with those families and provide the information they need for their lawsuit?
Folks from my office have met with the representatives of those families. We will commit to continuing to have communications, of course.
And provide the information they're seeking?
Well, you're saying I don't know what the information is you're talking about. So obviously I can't just commit to providing the information.
Well, let's talk about other information. Information about the Epstein abuses. Your predecessor apologized to the Epstein survivors with good reason, because as you've said today, mistakes were made. I'm asking you today, with Epstein survivors in this room, to apologize to them.
Well, so my heart breaks for every victim of any sexual crime, whether it's involving Mr. Epstein or somebody else. And so if you're asking me to apologize that this happened to them, of course, absolutely. This is a horrible thing, which is why this Department of Justice, this administration is focused very heavily on going after these predators. And so, yes, of course, that's part of my job as being empathetic to the
Will
victims
you
of crime.
apologize to them for the mishandling and mistakes that were made by the United States Department of Justice?
I will absolutely say that any mistake that we made should not have been made. And I very much, I can answer the question, or you can just interrupt me, Senator, but I am answering your question. I very much and I have said this to anybody that asks and publicly before, any mistake that was made is not appropriate. And so, yes, I am sorry that in about 1% of the documents, mistakes were made. But what I will say on top of that is we put tons of resources to rectifying those mistakes immediately, including pulling down documents within minutes of being informed that there were mistakes, potential mistakes made, and working 24/7 to rectify any mistakes. And that's what I would expect the victims would want us to do, and their counsel and this body as well.
And you would agree with me, wouldn't you, that you can well meet with any of the survivors or victims with their counsel present? You said you can't meet with them, but you could meet with them if they're.
I never said I can't meet with them. I said if they were represented, I had to meet through counsel. But of course, I can meet with them. I'm the acting attorney general of the United States, so yes, I can. I very strongly believe that if for these victims to tell their stories and the evidence that they have, they should meet, like any victim of a crime, with the FBI or a law enforcement agent, and that we will do everything we can to prosecute if we can.
The judge in Florida referred your misconduct. She concluded that there was misconduct and misrepresentation and improper purpose in that legal action to the Bar of New York for potential discipline, including losing your law license. I know you disagree with the result of the ruling. Has that kind of referral ever happened by a federal judge for an attorney general of the United States?
Can you?
I don't know, but I'll tell you something. That judge never asked us to respond. She never gave us an opportunity to respond to anything. And she didn't refer me. She just asked that a copy of the order be provided to the New York Bar, because there are several activist groups that have filed complaints against me. So listen, as I've said earlier, I think anybody on this committee, especially the lawyers that have practiced, can read that opinion and reach their own conclusions. But I very much disagree with the judge's insinuations about me. And we're going to do what we can to make that right.
One last question. Would you agree with me that agents of the United States should not fire into cars unless fire their weapons into cars unless there is an imminent threat?
Give a short answer to that.
There's a well-established standard as to when an agent can discharge their firearm, and I think that's something that should be followed in every case.
And that includes not firing weapons into cars.